Friends, now we are going to discuss the concept of review. You know that review is also an important feature in judicial proceedings. You see, the review is a mechanism provided by statute. It is statutory right. It does not exist unless granted by statute. That we have to keep in mind. Just like original jurisdiction, review is not equal to that original rights, fundamental rights. For original case. Regarding Supreme Court review, Constitution has not placed any restriction on the powers of Supreme Court of India to review its decision. There is no such power, such restriction. Specifically, Article 137 Article 137 deals with review. Now come to what is the verbatim of Article 137. So what is Article 137? We will see now. Article 137 says, subject to the provisions of any law made by Parliament or any rules made under Article 145. So, the power of the Supreme Court to review is subject to two conditions. One is any law made by Parliament or any rules made under Article 145. You know, Article 145 is the power of the Supreme Court to make rules. So, subject to these powers, the Supreme Court shall have power to review. The Supreme Court shall have power to review any judgment pronounced or order made by it. So, Supreme Court shall have power. Yes, Supreme Court shall have power. For what? For review. To review. Review of what? Review of Any judgment or order, any judgment pronounced, any judgment pronounced, any order made by it. So this is Article 137 says. So limitations, what are the limitations? Provisions of any law made by Parliament or rules under Article 145. This is the limitation. Subject to these limitations, the Supreme Court shall have power to review of any judgment pronounced or order made. That is 137. Okay. Come to the nature and scope of Article 137. So, what is the nature and scope? The meaning of the nature and scope, if you see, normally the orders and the decision of the Supreme Court are final. Suppose you take jurisdiction. What jurisdiction? Supreme Court has original jurisdiction, appellate jurisdiction, and advisory jurisdiction, election jurisdiction, special appellate jurisdiction. Like these jurisdictions are there. Suppose you take original jurisdiction, again Article 32, it is original jurisdiction, and transfer petition, it is also original jurisdiction. Election petition, dispute regarding vice president and president, it is also original jurisdiction. Like this. So, original jurisdiction. Next, appeal, civil appeal, criminal appeal, 132, 133, 134, like that. Articles. Election. Next, special leave petition, 136. These are jurisdictions. After exercising these jurisdiction, the decisions and orders of the Supreme Court are final. But there is no further appeal from the orders and decisions of the Supreme Court. We know that. Even then, to correct the mistakes happened by the court, it is well known that Supreme Court is final. Supreme Court is apex, but not infallible. Any wrong done by the court, what happens? It is not recoverable. Suppose it is remedialess. So when the Supreme Court is final authority, if order passed by that is caused a wrong to any person, it becomes remedialess. So to prevent that miscarriage of justice, Article 137 is there. The basics of the administration of justice. The basics of administration of justice are that no man should suffer because of the mistake of the court. What is the basics of the administration of justice? Basics is that no man should suffer because of the mistake of the court. So, there is a Latin maxim to say this rule. What is the rule? This No man should suffer because of the mistake of the court. Actus curiae neminem gravabi. What is this? Actus. I will write here. Actus curiae neminem actus curiae neminem gravabit. What does that mean? So, because of administration of justice, the basics of the administration of justice are that no man should suffer for the mistake of the court, because of the mistake of the court. So, this review power is there. Some of the situations, now we are dealing with the scope, some of the situations where the court may exercise such power. So, scope and nature. What are the situations the court exercises its power of review, correction? If a person has been wronged by reason of error of the court, the wrong must be removed. So, some of the situations, you take one, violation of fundamental rights, violation of the principles of natural justice, mistake of the court, judgments being obtained by fraud, that the court made the earlier order without jurisdiction, statutory provision not being brought to the notice of the court. These are some of the situations. I tell you again. Number one, violation of fundamentals of right. Violation of fundamental rights. Violation of principles of natural justice. Mistake of the court. Mistake of the court. Judgments being obtained by fraud. Judgments being obtained by fraud. The court made the earlier order without jurisdiction. So, without jurisdiction. And statutory provision not being brought to the notice of the court. These are the some of the situation. Okay, come to grounds. Come to grounds. If you take grounds, different in civil proceedings, these grounds different in criminal proceedings. Different in civil proceedings, different in criminal proceedings. So here Supreme Court has not given any specific grounds. As itself has not given any specific ground. It has taken grounds from the CPC, Code of Civil Procedure, Civil Procedure Code. Order 47. Order 47 of CPC deals, particularly Rule 1. Rule 1 deals with the grounds for review. Okay. Now see what grounds are mentioned in Order 47 in CPC. If you see CPC Rule 1, 3 important grounds are there. One is from the discovery of new and important matters. So after pronouncement of judgment or after making the order, the petitioner has been discovered of new and important matters or evidence. Discovery of new and important matters or evidence which after the exercise of due diligence was not within the knowledge of the applicant. So, it is not in the knowledge of original case. At the time of original case, he is not having such knowledge. Only after making the order or pronouncement of judgment, he discovered new and important matters or evidence. That is one reason. The second reason is such important matter or evidence could not be produced by the applicant at the time when the decree was passed or order made. Number one, not in knowledge. Number two, though it is in the knowledge, he could not produce by the appellant at the time when the original order passed. That is second situation. Then come to third situation. On account of some mistake or error apparent on the face of record, or any other sufficient reason. So, Class A contains, that means Rule 1 contains third reason. Third reason is several parts. One is mistake. Second one is the error apparent on the face of the record or any other sufficient reason. Any other sufficient reason is very wide word, very broad word, broad phrase. So let us see in detail. So these are the grounds for CPC. When you examine the landmark judgments, then we can understand in detail about the power of the review in civil proceedings. Okay. Here we must understand one fact that review is not rehiring. Review is not rehiring. That means what? Review should not be rehearing of the appeal all over again. Should not be rehearing of the case all over again. Only when circumstances of substantial and compelling character make it necessary to do so, then compelling and substantial character. Circumstances. Which type of circumstances must be there? Substantial and compelling character. where a glaring omission or patent mistake or like grave errors has found to be correct in the earlier decision. In Chandrakanta versus Sheikh Habib, Chandrakanta versus Sheikh Habib, in that case, what Supreme Court says, Chandrakanta versus Sheikh Habib. (1975) judgment. What Supreme Court says? Where a glaring omission, parent mistake, you must understand the words. Glaring mistake, patent mistake, glaring omission, patent mistake, glaring omission, grave error, So, three technical important words: grave error, patent mistake, glaring omission. In such a situation, it can be exercised. So, review is not at all a rehearing of the case. That is the principle. Come to some important judgments. You take Lily Thomas case. What is this? Lily Thomas case. Lily Thomas case. What held in this case by Supreme Court is that review is not an appeal in disguise. Review is not an appeal in disguise. Disguise means in another form. Disguise means in another form. So, okay, leave it. In Lily Thomas case, what Supreme Court said that it should not be appeal in disguise. Appeal in disguise. That is one. Its purpose was to ensure that justice was not defeated. What is the purpose? Justice was not defeated. Justice was not defeated. That is the purpose. And errors leading to miscarriage of justice were remedied. Errors leading to errors leading to miscarriage of justice were remedied. This is the purpose. See the purpose of the okay. So now important judgment is that in another judgment, Tungabhadra Industries Limited, in that it was held that there was a distinction between a mere erroneous decision and a decision which could not be characterized as vitiated by an error apparent. And review was by no means an appeal in disguise. Again, in Tungabhadra case also, it has been held that review is not to be an appeal in disguise. Error apparent is different, and a mere erroneous decision is different. Erroneous decision is different. Normally we write a ground. The judgment is erroneous. That is different. Apparent error is different. Okay. So this is about review part 1. We will see part 2 later.